This is Colin O'Keefe checking in for LXBN TV. Late last month, the Supreme Court weighed in on just how reliable a drug-sniffing dog has to be to constitute probable cause, making the issue just a little bit more cloudy. Joining me today to explain is Michael Zabel, attorney in Cozen O'Connor's Philadelphia office and contributing author on From the Sidebar. Michael, first off, can you explain the facts of the case and the background before arriving at the Supreme Court?
Sure. Well, there's this gentleman in Florida who got pulled over on two separate occasions by a Florida police officer and his drug-sniffing dog. The first time it was just a routine traffic stop. He had an expired plate. The officer noticed that he was looking a little bit nervous, and he noticed an open beer can in his car. So he brings out his dog, Aldo. Aldo does a little sniff around the car, and Aldo's trained to detect the scent of methamphetamines. And so he gives a little signal at his door that signified he smelled meth there. So the officer did a search of Mr. Harris' car and found ingredients for making meth in there. Eventually, Mr. Harris was charged with crimes related to possession of these ingredients. And then while he's out on bail, he gets pulled over again by the same cop, the same dog. They do another sniff, and this time they find nothing. Now, Mr. Harris challenged whether the officer had probable cause to search his car because he said that the dog Aldo was not reliable. He did not produce enough reason for the officer to search the truck. And that's what went on at the suppression hearing. Now, at the suppression hearing, the state of Florida put on evidence that Aldo had been trained, so had his officer. They'd gone through programs. And Mr. Harris's attorney argued, well, but twice in the field, Aldo smelled drugs that weren't there, and his certification was expired. The trial court concluded, though, that there had been enough evidence to show that Aldo was reliable. Florida Supreme Court, when they find out about it, they say, nope, just the fact that a dog is trained is not enough. And what the Florida Supreme Court does is say, no, the state has to prove, it has to produce evidence of training and certification. They have to produce record performance in the field. They have to do a lot of things. They made a whole big checklist. And that was the case that came up to the Supreme Court of the United States for them to consider.
And of course, as you wrote about, the Supreme Court disagreed here. Can you explain why they flatly rejected the Florida Supreme Court's ruling?
Well, the United States Supreme Court's jurisprudence on probable cause is based on totality of circumstances. The court has always emphasized a flexible test, meaning take a look at all the facts involved and make your determination based on that. What they don't like to do is have some sort of checklist saying you have to do X, Y, and Z, which is exactly what the Florida court did. And it was a unanimous panel for the Supreme Court, and one of those rare 9-0 opinions saying, Florida, this is not how you determine probable cause. It's got to be a little bit more flexible.
Absolutely. It's very interesting. With the Supreme Court normally being very divided, they come down unanimously on this issue. Once again, that was Michael Zabel of Cozen O'Connor. For more of his commentary on this case, be sure to visit FromTheSidebar.com. And as always, visit us at LXBN.com for more video interviews from LXBN TV, along with curated commentary from the Lex Blog Network's more than 8,000 lawyers. Thanks for joining us, Mike.
Thanks, Colin.